New Jersey's proposed legislation seeking to make it very difficult to carry guns in the state of New Jersey, despite the fact we won a huge Second Amendment case in NYSRPA versus Bruen, includes a lot of different obstacles and penalties for gun owners. One of the worst that they've come up with is this notion that in order to carry a gun in the state of New Jersey and exercise your right to keep and to bear, which means to carry arms, requires you to have all this liability insurance that we would never require for any other constitutional right. Stay tuned. We're going to talk about why this proposal to require Americans in New Jersey to carry firearms with insurance is unconstitutional. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court Bar, proud American gun owner, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. We were analyzing this proposed legislation trying to harass gun owners and discourage gun owners, in fact, from being able to carry guns in the state of New Jersey, even though we have the right to do so under NYSRPA versus Bruen. And I'm breaking down the various aspects of the New Jersey law, which of course is also applicable all across the country, even though many states don't have these laws. But it's important for you to understand the analytical and the constitutional framework for how to think about these problems under the Second Amendment, because you never know when you're going to be confronting some regulation or law that's a problem. So even if you're not from New Jersey, I think this video can be helpful to you to understanding the different things that the anti-gunners are doing, number one, and also to understand the analytical framework for you or your lawyers or whomever, if you're a judge or your law clerk, whatever it is, to be able to understand how to analyze these types of cases. So today, in this video, I want to talk about New Jersey's proposed legislation requiring that Americans in New Jersey that want to be able to carry guns in public for self-defense under their right to bear arms be required before they exercise this right to have some sort of liability insurance that covers them from any problems associated with them carrying guns. Well, this seems to be unconstitutional for a lot of reasons. Let me just go through the list. Before we go through the reasons why this is unconstitutional in all likelihood, I just want to read the relevant provision of Section 4 of the proposed legislation. Again, I'll put a link to the proposed legislation down below if you want to check out what I'm saying and read it for yourself. So this is what it says, quote, "Every private citizen who carries a handgun in public in this state shall maintain liability insurance coverage under provisions approved," this is the first problem, "approved by the Commissioner of Banking and Insurance, insuring against loss resulting from liability imposed by law for bodily injury, death, and property damage sustained by any person arising out of the ownership, maintenance, operation, or use of a firearms carried in public." Okay, it goes on and on. But here's the first thing I want to make a note. Did you notice that this insurance that you're going to be required to buy, I don't even know if it exists in the state of New Jersey. Because, for example, it says that the relevant insurance, as I read this, says provisions have to be approved by the Commissioner of Banking and Insurance in the state of New Jersey. So who do you think controls this commission? I don't know who's on this commission. Here's my guess. I am guessing that that commission is largely full of people that are politically oriented. And if you're in New Jersey, which is a radically blue state as a general matter, right? That's just the reality of it. New Jersey politicians probably have picked sort of politically left-leaning people on the commission. But the reality is, so this is a group of unelected bureaucrats, as best I can tell. They are going to be responsible for setting out the criteria for insurance that may or may not even exist to cover you, a gun owner, in the event you carry. So that's the first issue. Because we know that the anti-gunners like to manipulate the financial sector because they kind of have a lot of sway over it. We have to remember that one of the largest anti-gunners in history, at least in modern history, is Michael Bloomberg, the multi-billionaire. And I don't think I'm saying anything that's not obvious that Michael Bloomberg, he runs Bloomberg Financials. That is, he has got his own TV show, Bloomberg, that covers the markets and financial stuff. He's got his own magazines and publications. He's got his Bloomberg terminals. A very successful businessman, Michael Bloomberg is. 100% that's the case. But I think that we can say that Michael Bloomberg generally doesn't like people with guns. I think that's just general bias. There's no debate about that. And he donates in favor of sort of anti-gun, pro-gun control organizations. Okay, he has a right to do it. He's an American citizen. That's fine. But I think we have to keep in mind that one thing Michael Bloomberg probably has a lot of sway over is that he probably has a lot of sway over, various financial Wall Street related people, because he's either friends with them, he knows them. I would think if I had a business, if I were in the insurance industry, I will want to curry favor with Michael Bloomberg. I mean, I think that's a tremendous asset to be friends with Michael Bloomberg or to have him like you. Hey, I mean, the more billionaires you're friends with, I think as a general matter in life, that's probably a positive. So I'm just guessing that any commission involving insurance or financial products, which is what insurance is, a financial product, is probably going to be very interested in the views of Michael Bloomberg and people that are aligned with Michael Bloomberg, which as a general matter, I think we can say politically is generally anti-gun. So that's the first issue. Who exactly is going to be issuing these insurance policies that have to be approved by the state of New Jersey's, commission on insurance that I just discussed? Okay, that's the first issue. But let's go beyond that. There's constitutional problems, specifically constitutional problems. To begin with, where is the historical analog from 1791 that says that you can require insurance to carry a gun? Remember, the NYSRPA versus Bruen decision specifically says that you can have gun control legislation in America. That is allowed, provided that there is a historical analog in 1791 for that provision. So can someone point to me specifically a law or some analog in 1791, the year that the Second Amendment went into effect in America, or anywhere around 1791, that would allow or require people to be able to procure insurance of some sort before they were able to exercise their right to keep and bear arms under the Second Amendment, or basically insurance for any aspect of the Bill of Rights? I don't think that historical analog law exists. So therefore, I am seriously in doubt that that will fly anywhere. And by the way, we know that insurance did exist in 1791 because Lloyd's of London, probably the most famous insurance company, really set of companies in the world, has been around for not decades, centuries. And they were around before the American Revolution. So insurance was not a foreign concept to Americans or to the English-speaking world, because Lloyd's of London, again, existed before 1791 and insured things like, let's say, ocean-going voyages. So the fact that insurance did exist in 1791 and no one required it to exercise the right to keep and bear arms basically means there's not going to be a historical analog to justify this gun control law. The next reason why this is going to be unconstitutional, in my view, is because it's a tax. Now, I want to talk a moment about the difference between a tax and a fee. This is very important that you understand this. Government may charge a fee to you constitutionally if the fee covers the cost of the good or the service that you're using. What this is a tax. A tax is something the government charges that exceeds what you basically use. So for example, here they're requiring you to go out and get insurance, which has nothing to do with anything that you're not imposing any cost. If anything, I would argue that gun owners are actually bestowing a public benefit. They owe us money because we create a free rider effect where those that don't own guns get the benefit of people that do own guns, because the criminals may not attack, murder, and rape people that don't own guns. Why? Because the criminals fear that those people that don't own guns may have guns in their homes or otherwise. So the reality is, I would argue that gun owners are owed money from the free riders that benefit from other people owning guns, and therefore people don't have to have guns. But beyond that, of course, think about the absurdity of requiring insurance on other exercises of constitutional rights. Think about if you required insurance to anyone that attended a BLM or Antifa protest, or any kind of a protest or parade or whatnot. You charge these people and not just charge them, but require them to buy insurance before they go to the rally, before they go to a Trump rally, before they go to a Biden rally. Any one of the three people at the Biden rally, if you force them to buy liability insurance, that would be crazy, right? You wouldn't do that. And by the way, specifically, the Supreme Court has says this is not allowed in NYSRPA versus Bruen, because if you look at what NYSRPA versus Bruen says in footnote 9, they specifically say, in the context of requiring what you require to have people get a carry license. They specifically say, this is quote from the majority opinion of Clarence Thomas. Here's what it says in footnote 9. Any permitting scheme can be put toward abusive ends. We do not rule out, constitutional challenges to shall issue regimes, which is what New Jersey is going to, a shall issue regime, to shall issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. Now, if you require people to procure insurance, assuming there's even going to be insurance in New Jersey, because I'm not sure I want to write an insurance. We saw what they did with the insurance program to the NRA. I forgot what was it called, Carry Guard. I think we saw what New York State did to things like that. So why wouldn't they do something like that and try to discourage people from writing this kind of insurance in New Jersey? Because if you make it a requirement to get this insurance, but then you can't get the insurance because no one will write the policies because no one wants to run afoul of New Jersey, which is an important financial state because, Wall Street's New Jersey, New York, at least historically so. I think that's a stretch. I don't think that'd be allowed. But again, if go beyond that, it's absurd to think that if I want to post a blog, if I want to write an op-ed, if I want to criticize a political candidate, whatever it is, the notion that I would have to buy, let's say, media perils insurance, which is what it's called. Media perils means that, like a newspaper will buy a media perils policy because if they defame someone or do something like that, well, then they want to be insured like anything else. But to require any ordinary American that wants to exercise their First Amendment rights and speak out, whether it be on a public street corner, go to a protest, tweet their political views, whatever it is, to require them before they're allowed to do anything, to exercise the First Amendment rights, to buy media perils insurance in the event that they may commit commit defamation or commit a tort or commit fraud with their mouth or communications. That's absurd. That would never survive under court scrutiny. We also know, last but not least, that taxes on constitutional rights are unconstitutional. There's two main cases I want to talk about. One, of course, is Harper versus the Board of Elections, a 1966 Supreme Court case that said that a $1.50 poll tax was unconstitutional because you can't specifically tax constitutional activity. Now, again, you can have a generally applicable sales tax. It covers all sorts of things, constitutional and otherwise. That's fine because you're not specifically targeting constitutional behavior, which they did in Harper versus the Board of Elections in 1966. The Supreme Court struck that law down. But beyond that, there's also the 1983 case called Minnesota Star. And in the Minnesota Star case from 1983, the Supreme Court said that a tax on ink and paper that was used by the newspapers in Minneapolis was unconstitutional because it was basically imposing costs specifically on newspapers that were exercising the right of free press, the right of free speech, and you could not do that. So to me, targeting Americans with these insurance programs and imposing these costs on gun owners that want to be able to carry is a specifically targeted tax. So again, I think the bottom line is that this law is going to be unconstitutional for several reasons, one of which is a tax and not a fee. That's not allowed. You can't tax constitutional rights. You would never require insurance to exercise any other constitutional rights, so let's say the First Amendment. And the Supreme Court in footnote 9 basically said that you can't charge exorbitant fees in a shall issue permitting regime, which as I see it, this is. And I would also indicate to the extent that this insurance is not even available, and I don't know if it will be available, because if I was an insurance company, I wouldn't write this policy in New Jersey. I don't want to get harassed by New Jersey. I wouldn't even touch it. It's just not, I'm sure it's not profitable enough, for people like that. I'm just guessing. That's just my guess. I haven't done the numbers, but I would think that it's going to be, this insurance program may not even be set up in the state of New Jersey, because it's just not anything that I think a lot of companies want to get involved with, not because they don't like gun owners, but because they don't want to deal with the regulations in a place like New Jersey, New York, California, Massachusetts, places that don't generally like guns. And again, in light of that, that would be just an outright bar. If there is no insurance that you could even procure, well, now you basically have barred people from being able to carry, and yet again, through a government law. But nevertheless, none of this, as far as I can tell, is going to withstand court scrutiny for the fundamental point that in 1791, there is no historical analog to this law. There's nothing in 1791 that required people to have to get any insurance or anything like insurance in 1791. And because there's no historically analogous gun control law in 1791 that the anti-gunners are going to be able to point to now to justify this insurance requirement. And remember, the burden of proof to show historical analog is not on me, it's not on you, it's not on gun owners, it's on the government. So unless the government comes out with a 1791 statute that they can point to and say, haha, there you go, it is simply not going to work. The only other thing I think I should mention to give you a little heads up on, because I can't imagine they're going to argue this, but I'm going to flag it because, you know, sometimes the anti-gunners are like zombies. They keep coming back from the dead with their arguments. We've seen this before. The only other thing I want to mention to you, if they use the word surety laws, this is a warning to anyone in New Jersey. If you hear the phrase surety laws as a basis for insurance, that is nonsense. Nonsense. What surety laws were, what they're referring to, is something known as the Massachusetts model in the 19th century. What the Massachusetts model was in the 19th century was as followed. Everyone in the Commonwealth of Massachusetts was allowed to legally carry handguns and firearms, okay? However, in the event, and I'm not even sure there's a single case of this, I can't remember a single case of this occurring, but with that said, if there was one of your neighbors or somebody said that you were a threat to society or a threat to them, and the court after a trial concluded that you were indeed a threat to them or yourself, the court could require that you post a bond to continue to carry the gun, or a surety. And in the event that you violated it and misbehaved, you would lose the surety. You would never lose your right to carry, by the way. You would just lose the surety. But that is not analogous to requiring every single gun owner that wants to carry guns in public for self-defense to require them to have, to buy insurance, because the surety laws for Massachusetts, what the Supreme Court discussed and dismissed largely in NYSRPA versus Bruen, they just dismissed this as not analogous to anything. That's not analogous to here, because again, the only way someone was required to post a surety bond in the 19th century in Massachusetts was if you were proven to be a danger to yourself or to society, and you were required to post a bond, and then you were still allowed to carry, but you had to post a bond. But that's not analogous, because here they're forcing everyone to basically post a bond, to buy insurance, to post a surety. That is not analogous in any way, shape, or form to try to deter specifically designated bad people found to be bad by a court, which I'm not even sure this ever occurred, but to be found bad by a court in the early 19th century in Massachusetts to post a bond or a surety, not analogous to making everyone buy insurance as I see it. Okay, I know this is a complicated video about this proposed statute in New Jersey as it applies to really insurance obligations of people who want to carry. Hope you learned something though, and if you haven't subscribed, please do so, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.